Now that we've established that you should have been careful, that you owed a duty, second, that you weren't careful enough, that you did something or didn't do something that you should have, that you've breached that duty, we come to the third and final element, the third and final requirement of negligence, causation. Your carelessness must actually cause the harm that the plaintiff suffered. Let's have a bit of a look at that. So to help us think about this, I think it's good to go back to first principles and remember what the idea of damages are. Damages are an amount of money to compensate you for the harm that you've suffered, the damage that you've suffered. Now, from a legal perspective, the system has always been very clear that you really should only have to compensate someone if you're responsible for that harm. And that's the key idea here in causation. The damages in tort under negligence are not there to punish someone for being careless. That's not the role. The role is to try and make the person who has been harmed whole again because you did something wrong. And so if your action or omission didn't actually lead to the harm that they'd suffered, then you're not negligent because your carelessness didn't cause the harm. And this is covered by Section 11 of the Civil Liability Act. Let's have a look. So as this screenshot shows, causation comes down to two things. Factual causation, that is what you did or didn't do, your breach of duty, was a necessary condition of the harm, and that it's within the scope of liability, that it's appropriate for the scope of liability to extend to the actual harm. Let's look at those one at a time. Factual causation is asking the question, did the careless act actually cause the harm? And courts have traditionally used the but-for test. But for the defendant's carelessness, would the plaintiff have suffered harm? That is, in the absence of the defendant's carelessness, the plaintiff would not have suffered. Put another way, the defendant's carelessness caused the plaintiff's harm. That's what we're really trying to get to. So I'll leave you to look at Adil's Palace as a case. I actually think a different case that makes this point clear is Barnett and Kensington Hospital, which involved a case of a guy who turns up at a hospital vomiting and complaining of stomach pains. And when he comes to the hospital, so let's have our hospital here. So we've got our hospital. So he goes to the hospital and it turns out that the doctor actually isn't on duty. I think he was actually home in bed sick with the flu. And the guy who's actually being sick and vomiting, I shouldn't really do that, should I? But the guy who's being sick, he actually talks to the nurse and the nurse rings the doctor. She phones the doctor who's on call and the doctor says to the guy, well, why don't you go home, come back in the morning if you're still sick or see your GP. Now, the doctor did not see or examine the particular guy who comes in. So, first step, did the doctor owe a duty of care? Doctor patients, yes, they owe a duty of care to people presenting there. Second, did he breach it? Yes, like he could have got other people to look at it. The probability of there being something seriously wrong is pretty high. The seriousness, yes, well, he ended up dying, so it's a serious issue. And would a reasonable person have taken precautions? Yes, they would have. They would have got someone else to look at him, got another doctor in. He could have come in. He could have sent him to another hospital immediately. 100 other things. So the doctor owed a duty. The doctor breached the duty. But when they did the autopsy and worked out why the guy died, why did he die? Arsenic poisoning. Someone had poisoned him. I think it was the wife, actually. Someone had poisoned him. And so the guy would have died whether or not the doctor examined him. There was nothing the doctor could have done to save this particular patient. The doctor's carelessness in not examining him didn't cause the death. The arsenic poisoning did. That is a great example of a case where there is no factual causation. So we have to get that direct link between what the defendant did or didn't do, their carelessness. We have to link that carelessness to the actual harm suffered. The second thing, and it's an important element, but we're not going to deal a lot with it in this subject because we're not going to become lawyers. We just need to be conscious of this because it's one of the tests, that a defendant's liability, what they're responsible for, can only extend to reasonably foreseeable consequences. So notice again, our good friend reasonable foreseeability is coming through, but it's a different test, right? Again, it's not this test of if the risk was reasonably foreseeable, it's were the consequences reasonably foreseeable. For instance, if I do something careless and you trip over, you breaking your arm is reasonably foreseeable. Tripping, falling, breaking your arm, that's reasonably foreseeable consequence. You needing some painkillers, reasonably foreseeable consequence. You getting addicted to painkillers, that's the harm, right? Is it reasonably foreseeable that someone could become addicted to the painkillers prescribed to them if they trip over and fall? Yeah, okay. But see how we're getting to the limits? What about if you start taking heroin because the doctor cuts you off because they know you're addicted? Now that's not reason. Is it reasonably foreseeable that you'll start using heroin because, okay, no. But again, the test here is we're looking at the consequences of the actual risk. In breach, we're looking at the risk, and in owing a duty, we're looking at any kind of carelessness causing some kind of harm, the relationship. So the test for foreseeability shifts as we go through each element. For our purposes, we've just got to make sure that the harm that's suffered is a reasonably foreseeable consequence of the carelessness, linked closely enough. And if we can do, we have therefore established that you owe a duty, that you breached the duty, and the breach caused the harm. Once we hit that point, we can clearly say that at law, the defendant is negligent. But we don't end there. Just because the defendant is negligent doesn't mean that they're liable. It doesn't mean they're going to have to pay all of the damages suffered. And to understand why and how we know this, we're briefly going to look at defences in our next couple of videos.